First thing you got to look at is the caption of a bill. If it says the puppies and apple pie bill, you know that somewhere in that bill they're going to be killing puppies. Okay?
I think that's the quote of the night right there.
Somewhere they're going to be killing those puppies, and they're going to be stepping on that apple pie, maybe even banning them. Pay attention to the caption of that bill. If they say we're going to do this to protect your privacy, watch out for your privacy.
In the first of several podcast episodes on privacy, Scott McCollough, an Austin-based telecommunications and computer law attorney, speaks at EFF-Austin's monthly meeting. Scott does a deep dive into the intricacies of privacy law.
I don't know if y'all know me. I've been around for quite a while. Been doing telecommunications and computer and information law since the 70s. Mostly in the Austin area, but I do have a nationwide practice. I usually represent service providers, but only certain types. I'm very particular about the folks that I represent. You will not find me representing an AT&T or a Verizon. I typically, although I work with them from time to time, I won't work with the Google. I'm very selective about who I represent and what I do for them. Because one of the driving things that I've had is just a personal passion, is I care about the individual. I care about people as consumers, I care about people as citizens, and I care about the impact of governmental policies on the individual. It may not surprise you to learn that my political philosophy kind of bends towards a libertarian, small L libertarian. And so I am usually in a position to say something that offends everybody. And you can probably expect that I might say something that you may not really want to hear. But you can be assured that I'm here today to advocate a position, but I'm also here today to try to help us get a firm understanding about this thing called privacy. I can argue this as a lawyer and somebody who tries cases all the time. I can argue any proposition from any side. It's just what they train us to do. And so, I can present the argument on the other side of virtually anything. When I'm going into a case, the first thing I do is put myself in the other side's shoe and figure out how I would attack a problem. And that's the best way to defend or go after somebody. The Constitution does not explicitly mention any right of privacy. In a line of decisions, however, going back perhaps as far as 1891, the court has recognized that a right of personal privacy or a guarantee of certain areas or zones of privacy does exist under the Constitution. Personal rights can be deemed fundamental or implicit in the concept of ordered liberty are included in the guarantee of personal privacy. That comes out of Roe versus Wade, a case that probably most of you are well familiar with. In Roe versus Wade, the court was actually looking at the entire Bill of Rights and the underlying concepts of liberty that form the basis of it. And it found that this particular right of privacy, in that case the right of abortion, arose through the penumbral rights of the Constitution, including the First, the Fourth, the Fifth, the Ninth, the 10th, and of course the 14th. And in particular, what's known as the Due Process Clause of the 14th Amendment. And so Roe versus Wade was one of the seminal cases dealing with this right to privacy, and which is, as we will discuss later on, really rooted in the right to liberty, the liberty rights which are spoken of in the Constitution and the Declaration of Independence. Now, another case, Washington versus Glucksberg, a case, by the way, which is one of the favorites of the current nominee to the Supreme Court, Justice Kavanaugh, also adds that in order for these, what we call in the law an unenumerated right in the Constitution, also needs to be deeply rooted in the nation's history and tradition. And those who are against the right to abortion often use that last prong, which was actually not mentioned and probably on purpose in Roe, as one of the reasons why the right to privacy as found in Roe, specifically with regard to the right to abortion, probably was not proper. Now, I'm not here to talk about abortion, okay? But, like the right to abortion, we as individuals have a certain set of rights, a bundle of rights that we carry around with us all the time. And they are all based on the various aspects of what's expressed in the Declaration of Independence, and then expressly stated in the first 8 amendments, 9 amendments to the Constitution, and then the 14th Amendment, and particularly the Due Process Clause. Abortion is one of them. These are liberty interests. Now, I hope to convince you tonight that information privacy, as a distinct privacy and liberty interest, is a part of a fundamental and recognizable realm of sanctuary surrounding every individual, quoting the Monroe versus Pape, which was a 1983 case brought by African Americans whose house had been invaded by the police. They were given a remedy in that case. That the right to information privacy is implicit in the concept of ordered liberty and deeply rooted in the nation's history and tradition. I contend, and I'm not alone, I contend that information privacy meets the test for so-called unenumerated rights and is protected from arbitrary intrusion by the police. Let's see how many agree at the end. I put together quite a few pages of historical and other references, and we may flash them on the page. But let me tell you something, I'm not going to give you death by PowerPoint tonight. I'm not going to read from all this stuff. I'm hoping more to have kind of a guided discussion. And there's a lot of different ways to look at this. For example, one of the source materials that I use, I'm not sure I cited it in this, is the Stanford Encyclopedia of Philosophy. They have a really good paper that I would commend to you that looks at privacy from a philosophical and ethical point of view. And of course, they address the law. One of the modules in there is the feminist critique of privacy. Now, what do feminists have to say about privacy? Those of us who are in the digital arena and really zealous advocates of privacy might be surprised to learn that many feminists are not really excited about the right to privacy. They think it can be used as a tool of oppression because it keeps secret many of the offenses which have been, and power plays which have been portrayed against women. And there is an argument for it. There are others who argue against privacy. One of the most notable was, of course, Robert Bork, who did not make it to the Supreme Court, largely because of what he had to say about privacy. Another, an economist by the name of Richard Posner. I don't know, those of you who follow economics, Posner has a view about privacy. He thinks privacy is inefficient. And indeed, individual privacy is contrary to the liquid of commerce. And that only the privacy rights of corporations should be honored and not that of individuals. I would disagree, but the fact of the matter is there is a range of views on this topic. Let's start with why privacy is important. Now, I've given you my suggestion here, hopefully in relatively concise form. I think that privacy is important because it supports individual liberty and autonomy. We're all autonomous people in this world. We have the right to make individual decisions about ourselves, how we will conduct our lives. One of those decisions is the kind of information that we wish to keep to ourselves and share with others on a limited or on a wide open basis. Privacy, in my viewpoint, also has very much has property implications. We own ourselves, just like a woman owns her body. And that is one of the bases that the court found in Roe. The abortion actually is reflective of a property interest. So we own our body. We own our decisions. We have a right to decide what we will share with others. It is within the bundle of rights that comes with privacy. the terms and conditions upon which we will allow others to obtain and use information about ourselves. Finally, just from an ethical and philosophical perspective, privacy provides functional benefits because it advances the human condition and it preserves ordered, polite society. Aside from the law, what do you often hear from people? Mind your own business, right? Good fences make good neighbors. Why? We're respecting each other's privacy. If you start invading somebody's privacy, they get angry. Somebody starts looking in my window, especially my bathroom window, I'm not too happy about that, and I'm likely to do something about it. Well, so there's a reason for this. We have an innate sense of self-determination and a right to control our bodies and those aspects of our bodies and the aspects of our life. So just from a ordered society perspective, privacy is important. All right, so what is privacy? Somebody said something a little while ago, and they said the right to be let alone. Who's it? You did it. Very good. By the way, that's right here. Judge Cooley, Warren, and Brandeis described the right to privacy as the right to be let alone. Now, the context that they were talking about was in the legal context, and specifically at the time in their seminal paper from the 1890s, the right to privacy, they were talking about the civil tort of invasion of privacy. They were recommending that the common law, not the statutory law necessarily, but the common law, recognize a cause of action. And they've now, Dean Prosser, characterized them into 4 types. Okay? Actionable as against someone, another individual on the civil side, that violated your right to privacy. Prosser went through all of what Warren and Brandeis and some of the common law had said, and he identified 4 distinct torts, which is a cause of action. I can sue somebody under tort, right? Intrusion into solitude, publicizing private facts, false light, portraying you in a false light, using what even may be factual to put you in a position that isn't true, and appropriation of name or likeness. And so, in a legal sense, the right to privacy is indeed the right to be let alone. But there are others in the non-legal context who have described it in different ways. Let's see. There are some who describe it in terms of information control. If we're talking about the right to privacy more globally, that's not entirely correct because there are other privacy and liberty related interests that are about more than just information. Abortion being a good example. Privacy is the condition of not having undocumented personal knowledge about one possessed by others. Similarly here, it's about intimate decisions about intimate access. That was actually reflected in a Supreme Court decision called Griswold versus Connecticut, which dealt with the right to contraceptives, predated Roe. So, one of the problems that we have in the legal context and even in the societal context is there's not really a uniform definition of what privacy is. It can be a big thing or it can be a little thing. It can be about information. It can be about decisions. It can be about a host of matters. And so, ultimately, privacy is something that can really be, is context specific. One thing about privacy as it has been considered over the years, and trust me, people have been talking about this concept for a very long time. The actual derivation of the term has specific meaning. Private and privacy derive from the Latin privus, meaning single or individual. And so private is the opposite of public, and therefore involves something separate or not involving the public. And the public in this context can either be the people, other people, or the state. So there is this dichotomy There is that which is about the individual and about individual decisions and facts, and then there is the outward-facing view of a person within the greater realm. This was the way that ancient philosophers looked at it. For example, Aristotle. Anybody doesn't know who Aristotle is? Aristotle distinguished between the public and the political sphere. He called the political sphere the polis, and the private sphere of the family the oikos. And he was one of the people who first decided that while you are in the public sphere, you have lesser rights and you have certain obligations within society. But once you come back within the oikos, you have a different set of rights, duties, and obligations. And the way that you look at a situation will often depend on whether we are dealing with the polis or the oikos. Others picked up on that. St. Thomas Aquinas. Anybody aware of who St. Thomas Aquinas is? Go ahead.
He was a Catholic theologian who formulated natural law theory.
Very good. Very good. It's exactly right. Dang, I should have talked to you before I put this together. St. Thomas Aquinas, during his time, the Roman Catholic Church had very much gotten away from the old Greek philosophers' way of doing things. And what Thomas Aquinas was trying to do was reconcile the two. And he developed this theory of natural law. So, like Aristotle, he advocated for individual reason in pursuit of virtue. He believed that the natural order of justice limited rulers' authority. And even rulers must obey the law. The state has no power other than that which is given to them by the people. And he believed that if a tyrant arose, it was incumbent upon individuals and the rest of society to depose that tyrant, even to the point of sacrificing oneself to do so. That was an act of virtue. But what he was describing was a set of rights as well as duties that every individual had. Now, of course, he put this in a religious sense. And in terms of a communication with God. But the rights that came down from God in a natural law sense were those dealing with the individual as against society in general and the government in particular. John Locke in the 1600s from Great Britain also picked up on natural law theory. He too used this public-private perspective that had first been articulated by Aristotle. He perceived privacy to be a property interest. And that is important if you begin to listen to the legal scholars of today discussing whether privacy is a right protected by the Constitution. You will see a lot of discussion in it if you happen to read the most recent decision by the Supreme Court in the Carpenter case. One of the justices who dissented, newly installed Justice Gorsuch, he dissented from the decision protecting cell site location information. But he would have protected the information too, just using a different theory. He thought this information was, in fact, the individual's property and protectable as such, whereas the majority of the court decided to adhere to what's known as the old reasonable expectation of privacy test, and they chose to not extend the so-called third-party doctrine to it. Now, to me, that was a lot of just careful dancing. I'm actually quite attracted to Judge Gorsuch's theory and approach, and we're going to come back to that in a minute. John Stuart Mill
not often thought of as somebody who was a natural law theorist. In fact, he's known more as what's called an act utilitarian, someone who believes more in positive law, man-made law, as opposed to natural law. He too, however, advocated in favor of individual rights and individual privacy. And he too used this public-private distinction to do so. Even act utilitarians, if you press them, will recognize that there is a zone of individual privacy that needs to be respected. They come to this conclusion, however, for purely utilitarian purposes. They don't do it for moral reasons. They do it because it's efficient, because it reaches the right outcomes. So there is a broad spectrum in philosophy and theorists in moral law respecting the need for an individual to have control over themselves and including information about them as against the rest of the world, and in particular as against government. And our founders well knew this. They did. The founding documents of our country are replete with references to individual liberty interests, privacy interests, and rights as against the government. For example, James Madison, he often expressed Lockean views. He believed that a person's ideas, beliefs, and abilities and the opportunity to exercise them are the most treasured property. Notice how I keep coming around to property. To me, privacy is property. Information is property. And our founders recognize that. A man has property in his opinions and the free communication of them, said James Madison, and has a property of peculiar value in his religious opinions and in the profession and practice dictated by them. Back then, of course, religion was really the moral code by which people lived. And so we should not be put off, those of us who may not be particularly religious, should not be put off by the religious tones used by our founders. They were really talking about morality. The safety and liberty of his person is property very dear to him. A man is said to have a right to his property, and he may equally be said to have a property in his rights. Thomas Jefferson also should be familiar to all of us. He often explained that the words he wrote in the Declaration of Independence about the right to life, liberty, and the pursuit of happiness were written into the Constitution and in particular the Bills of Rights. Indeed, he always contended that a primary purpose of the Constitution was to put in very specific words that set of rights to life, liberty, and the pursuit of happiness. It is to secure our rights that we resort to government at all. The very purpose of government, according to Jefferson, was to secure individual liberty. John Adams, similar times, expressed similar views. Rulers, he claimed, are no more than attorneys or agents sent away to protect our individual interests. And the people, if they betray this trust, the people have to revoke their authority and substitute other agents who will act to protect individual liberty. Alexander Hamilton, you know they ought to write a play about that guy. Discussed the principle as part of the debate leading up to the Constitutional Congress. He too spoke of and invoked natural law with reference to the right to privacy. Let me talk about natural law for a minute, although if you want, I can talk about it from a utilitarian perspective as well. Does this natural law right, as discussed by the ancients and put in place by our founders, can it actually act to supersede man-made law or positive law? The answer is yes. The easiest way to describe that is, say you have a state statute that says the police can knock down your door and steal your papers without a warrant. Well, obviously, that would violate the Constitution, which derives from natural law. But there are other instances as well. Roe v. Wade, again, to return to that. And again, I'm not here to debate abortion, but I use Roe v. Wade because many of us in the law recognize as a practical matter that that's not only just precedent. There's precedent on it. It's almost super precedent. And so the things that the court said in Roe versus Wade can often be used and applied to other topics. Yes?
Can you talk a little bit about the difference between man-made and natural law? How's the Constitution not, you talked like the Constitution was derived from natural law. How can you have any sort of sense of natural law without a sense that there's some higher power that, bestows things upon you?
Well, natural law does not require one to believe in a deity. Natural law can be entirely justified on non-religious terms by appealing to reason. And those of us who like to apply reason in a logical sense without having to try to believe in some mystical being can quite easily get to the same place as those who believe in natural law. You simply follow reason in the pursuit of virtue. Now, if you're asking me, and I think where you were going is, well, isn't the Constitution
just as man-made as any law passed today?
Yes.
It's a greater precedent because it's been around a lot longer. But
Isn't it just positive law because we made it?
Technically, it is positive law, and certainly there are many aspects of it that are. The parts that discuss separation of powers, for example, Article 1, 2, and 3 in the Constitution itself, yes, that's positive law. You bet. Now, I would say, however, that the Bill of Rights, which was added as a result of the first Congress after the Constitution was adopted, that is really just an expression of natural law. It was written based on natural law principles. So technically speaking, yes, the Constitution is positive or man-made law, but its underlying principles derive directly from natural law, especially the first 10 amendments.
Would you say that this natural law implemented in this frame, as we were speaking about, that would be shifting the ownership from the individual to the state?
What I'm trying to suggest, and there's a little bit more of this later.
The state owns your rights, and then they're grants them back to you.
The point is, we own our rights, and they are inalienable. Our rights are inalienable. The government is there only because we have allowed it to be there, only because we have created it. The government is not there to rule us. It is there for our convenience. They are our agents. We are their principals. And so the government does not give us rights. We have surrendered some rights in order for there to be ordered society. And the question is, how far need that go? So there are numerous cases where the Supreme Court and the Supreme Court of other states have found that natural law, and in particular some of the inalienable rights expressed in the Constitution and the Bill of Rights, can operate to supersede man-made law. It goes as far back as 1886, where the court was providing a remedy for an unlawful entry, warrantless, by the police and their pillaging. At the time, of course, we had the warrant requirement. But there really was not yet a remedy. The court had not yet, for example, come up with the so-called exclusionary rule, which forbade the admission into evidence in a criminal trial of the fruits of a warrantless entry. Nor had the court completed the process of extending all of the 14th Amendment due process provisions to the states. And so when Ohio, for example, when Ohio agents broke down somebody's door and made off with all of the goods. Not only did the court condemn it because of the Fourth Amendment, they also gave these particular people a remedy, very reminiscent of what we now call 1983. They were able to sue in tort those who broke down the doors and recover money. Now, you will remember when I started off, the first thing I read that the court has said that these unenumerated rights are not unlimited. It is only those that are necessary to ordered liberty and well recognized in the human condition, especially that led up to the Revolutionary War times. So it's interesting to take a look at what ancient law did with regard to the right to privacy. You may be surprised to learn that Roman law actually protected the right to privacy. One actually had the right to seek recompense against those who did come and take your property and invade your privacy. Invasion of privacy wasn't called that at the time, but it was an actionable thing in the Roman courts, not only as against the government, but also as against others. There's a case out of Georgia from 1905 where it's a beautiful opinion, by the way. Y'all ought to see it. I've got it linked here. It's the Pavish case, where the court goes through and draws a line from Roman history and discusses the Roman civil code causes of action for the right to privacy. And by the way, once again, they weren't just talking about the recovery of items that were taken. In Roman law, one was also able to get relief from somebody who would be peering in your windows, acting in a voyeurish manner. There was a remedy for it. It was a recognized right to privacy. In Great Britain, British common law accepted that. Yes?
So I guess, this is really interesting, but I guess I'm kind of curious about not the what of what the laws were, but the why. So, for instance, to prevent someone peering in your window, right? This is ancient Roman law. Why was it that way? Was it because these were inalienable rights? Was it utilitarianism, where we wanted the greatest amount of good for the greatest number of people is to prevent harm to your property? Is there any, do you know what the actual reasoning behind, again, the theory of the law, not the letter of the law?
I think, especially in the Roman law context, because that was a civil code, it was not a common law code, it was a civil code, it was more of a utilitarian perspective. The authorities recognized that in order to maintain ordered society, it was important to protect the abode and the small few things that even the lowest Roman citizen could accumulate at the time, from having someone of equal stature or higher stature come in and make off with it. Right. So it probably was more of a utilitarian perspective than anything else, necessary for ordered society. One of the later modules, which we may or may not get to here, okay, actually talks about the efforts that have been made over time to protect information from others' eyes, including codes. And all societies, whether it be the Chinese or ancient India or the Assyrians in the Middle East and in the Persian area, all of them found it necessary to find ways, using codes and other means, to hide or otherwise protect information from prying eyes. And so I would submit that virtually every society, not just the ones that the old white people from European societies that we like to look at, but all societies from throughout the world have always recognized the need for there to be some form, some measure of individual privacy. So let's just get to that now. I'm going to run through this because I'm probably in a room of people who know far more about this than I do. Okay? But, there have been efforts throughout history to protect information from prying eyes. Cryptology is Greek for hidden words. And the goal is to keep communication secret from all but the intended recipient. Anybody here who isn't well versed in cryptology? Because I can run through the basics, but if all of y'all know this, I can just skip this, all right? So we all know that there's ciphers, codes, and concealments, right? All right, good. The early Chinese leveraged the ideographic nature of their language to hide the meaning of words. That was a form of concealment. In India, early rulers used alphabetic substitution codes through phonetics and often communicated the message using sign language. The Kama Sutra has a section on how to cipher with your loved one. The Sumerians and ancient Egyptians used cryptography and sometimes compounded by substitution between cuneiform and hieroglyphics. The Mesopotamians, Babylonians, and Assyrians used cuneiforms to encipher during the same period. Hebrews did substitution ciphers using the Roman alphabet in 1600 BC. The Spartans used transposition ciphering in 500 BC. In 499 BC, Hystasius employed concealment by shaving the head of his most trusted slave and then tattooing a message telling Aristogoras to revolt against the Persians. He had to wait until the hair grew back before it would work. That was a form of concealment. During the 15th and 16th century, ciphering and codes considerably advanced with means to encrypt and break codes. Mary Queen of Scots died because she used an ineffective form of cipher. Queen Elizabeth. Queen Elizabeth, her chief code breaker, broke the code and off with her head. The British and American revolutionaries used, both British and the revolutionaries, both used codes during the Civil War. In fact, there's a substantial argument that can be made that we would not have won in the Revolutionary War, but for encryption. So, my response to those, like we have just most recently heard reaffirmed once again, demanding a backdoor to encryption, that, we've got to give up a backdoor so that the government can get in either with or without a warrant. My response to that is, well, King George would have loved to have that back in the day. Thomas Jefferson used codes. He even invented a wheel cipher during the time he was ambassador to France. Indeed, his wheel cipher was reinvented by the military and was the basic code that was used between 1922 and 1945. The most famous, of course, is the Enigma machine, which was broken. What many fail to remember, however, is that one code which was never broken was the use of Native American and Basque code talkers. They used a form of obscure languages and dialects with strategic word substitution. Today, most encryption is done electronically. I'm sure, again, all of y'all know how to do that. One of the big topics of the day is the extent to which normal, ordinary people will be allowed to protect their own information as against the government using encryption. Whether the government should be allowed to access encrypted information while in transit or while in storage, and if so, upon what conditions. So let's talk about that. Now I'm gonna very quickly run through some of the law on encryption, and in particular whether somebody can be compelled to disclose the key. This law is evolving quickly. There was a recent decision just a couple of weeks ago that is really, I was fascinated by the decision. The federal courts have actually a mixed record on this, and they often turn on some very arcane legal principles that make no sense to a normal human being. But in the most basic terms, let's just kind of analogize the encryption key to the key to the lock. Okay? If you have a lock and a key, the government can't just come and break that lock without a warrant. But can they make you give them the key so that they can open the lock with a warrant? The answer is yes. Yeah, they can make you give them the key. Well, doesn't that violate the Fourth Amendment? No, not if there's a warrant. No. Does it violate the Fifth Amendment? No, because the Fifth Amendment is self-incrimination. It requires, it protects only the use of your mind, the conveyance of information. Yes?
What if that information, instead of a key, is more like a password, something that is only contained inside your mind, that cannot be accessed any other way? You never wrote it down. There's no other way they can get it than physically compelling you to spill the contents of your mind.
The first answer is, if you must use your mind in order to convey the information, here, a decryption key, then you cannot be compelled under the Fifth Amendment to disclose it. But there's an exception. And the courts love it. I hate this exception. It's called the foregone conclusion doctrine. If law enforcement can prove that it is already a foregone conclusion that the information that they want you to have to give the key up for is yours, and they already pretty much know what it says, pretty much, okay, then you can be compelled to disclose it under most of the cases, both state and federal. So you have to be very careful about the foregone conclusion exception to the can't make you use your mind approach to the Fifth Amendment. Yes.
Has the Supreme Court upheld the foregone conclusion?
Yes.
And under what justification?
The first time they did so was actually in a case involving Aaron Burr.
Really?
In fact, modern foregone conclusion law, as it was originally being developed, was based on the Supreme Court's decision in the Aaron Burr case. And it wasn't because he had a shootout with him. Yes, he was using encryption, which he had dictated to his aide, in order to supposedly enrich himself with regard to the sale of land out west. Jefferson, who was president at the time, I believe, got wind of it, and there was a criminal case. They hauled in his clerk and tried to force the clerk to give up the key. And without going through all the wordy words that they used back then in the Supreme Court decisions, basically said, well, it's a foregone conclusion. We know what this stuff is. So, yeah. As it turned out, however, they still couldn't get the information, because when the clerk actually began to testify, he said he couldn't remember. So, the foregone conclusion doctrine is a real problem. There's really only one way to protect information, subject to this really interesting case I'm going to discuss in a second. At least under the federal court decisions, there's really only one way to make sure that the government can't compel you to give up the key. Don't tell anybody that you got the file. Okay? Don't tell them. Don't tell anybody what's in it. And don't tell them that you're the one who encrypted it. If law enforcement cannot prove those three things, then the foregone conclusion doctrine is not met, and they cannot compel you to give up the key. By the way, by way of technology, I hope all of y'all are smart enough to know that all of these new methods to unlock phones and even to decrypt information stored in transit using biometrics
That's not going to save you under the Fifth Amendment. Forcing you to look into a phone is not testimonial, it's an act. And so if you have your information locked up or encrypted using a fingerprint or other biometric information, Fifth Amendment isn't going to save you. It's only a key that's in your head and can revealed only by information in your head that you must speak.
This is an interesting hypothetical, Scott. Based on current lines of research, they're eventually going to be able to read our minds. Can they compel the key if they could read it as the thought in our mind?
Well, interestingly enough, that sort of gets us to this case that I've kind of given hints to.
I'm just telling you what DARPA's working on. They're actively working.
Well, and in fact, I have read of studies where they actually now are able to tell, what sorts of things you're thinking about. I don't know what's going to come of this. It's a really relatively, very recent court case out of Indiana. Those of you who have my paper, it's discussed on page 16. It's called Sayo versus Indiana. Brand new argument in favor of Fifth Amendment protection, and it's based on technical grounds, completely separate from whether revealing a key is testimonial. The state appeals court found that forced decryption requires the defendant to recreate the information the state is seeking, and that's testimonial. Remember how encryption works. What encryption does is it scrambles all the information, so that you cannot, somebody who is looking at it cannot determine what those ones and zeros represent. In digital form, the information isn't a word. I mean, we all know this, but we don't think about this very often. It's what the ones and zeros represent that has meaning. And so the act of first encrypting and then second encrypting is actually a reordering of information and a changing or a hiding or unhiding of what the information represents. And so what this court was saying was that by the act of disclosing a key, not only is that testimonial, it allows the state to not find the information, it recreates the information. For those of you who understand something about the law of evidence, in other words, it's hearsay. Now this seems eminently technically correct to me, and it is not something I have thought of. I've dealt with these issues. I've studied on these issues forever, and we're all hung up on whether disclosing a key was testimonial. But what about the act of decryption itself being testimonial? This court found that it is. So, no, federal courts haven't addressed this. This is a brand new thing. I've never seen it before. Nobody I've talked to has ever thought about it before. Some genius came up with it, and the Indiana court bought it. It's a great opinion. I commend it to you. Maybe those of you who are real geeks and understand how encryption works can articulate in better terms what I'm trying to say.
You pretty much said it correctly.
So to put that back to a more physical analogy, if the act of decrypting is recreating information, with shredding documents, or just inserting a whole bunch of ones in between the figures of a paper, and would trying to recreate that information, would that be testimonial in the same way? Like anything that you do to shred, to get rid of evidence, and if that the state can recreate in a physical manner, would that be testimonial in the same way that decryption is?
It would be, but remember what we're talking about here is whether the person who asserts or has ownership of it, or at least arguably created it, can refuse to help the state. Now, if the state can independently figure out what this stuff is, as the federal government did in the San Bernardino case, with regard to the Apple. Remember the iPhone that the San Bernardino killer used? It was all that litigation. I was in that case. It was fun. We had a great time. And we thought we had a really good case. and then all of a sudden the federal government just went away, right? Because they found somebody that could decrypt it. Now, from a legal perspective, the question within SHIFT is no longer a Fifth Amendment question, okay? It's no longer a warrant question. The question is whether the government can show with clear and convincing evidence that this recreation is what they say it is, and is in fact a faithful recreation. And quite frankly, I'd have a good time talking to them about that. I'd have a really good time talking about that.
Well, I mean, yeah, the technology person in me is now thinking of all sorts of fun arguments about the hash function used to restore it and whether if it guarantees uniqueness or not. Because maybe this is some random string they put together that via their decryption algorithm says what they want it to say. You can construct such algorithms.
Yes, you can. Although I will say I'm not real pleased with it, but in the copyright area and in the child pornography area, one of the ways that the state is proving up its case now is by using hash values, recognized hash values of child pornography. And,
They're literally building a rainbow table of known sources.
Yeah, and once again, I can imagine the fun I would have talking to the expert who can testify that this is in fact a true and correct conclusion. But it is ultimately just an expert conclusion. And hopefully it would end up going before a jury rather than being decided as a legal question before the court.
That sounds kind of like the Napster case, right? They take the music and make an electronic file of it. Is it really the same song, or is it something new that the person's created, right?
I mean, it's actually very much analogous in the sense that one of my favorite arguments Cory Doctorow gave to illustrate the absurdity of current copyright law.
Right.
He basically said that you could, on a Linux system, you could copy a media file and direct the output to be saved to the null pointer, which basically deletes the data stream immediately. And so if you did this a million times, you would still only have one song, but under current copyright law, you're liable for billions of dollars in damages now.
Well, I still have my CESS tie. I don't know if you guys remember that one, right? The CESS on the copy protection for discs. All the lawyers in the case were prohibited from discussing the formula in open court, and so we all had a tie.
Oh, this was the forbidden number you couldn't say.
CESS written out in pearl. I still have that tie. We're getting a little short on time, and I really do want to, move on and also save time for discussion. Let me just try to tell you something. Let's just be straight, okay? If you got something you don't want people to see, especially the government, don't write it down. Don't share any of it. Okay? It's not a secret if more than one person knows it. There's no absolute certainty once you share any information about it. If the government can prove through testimony or otherwise that you have admitted ownership and possession of a document and that you were the one who encrypted it, they can compel you under the foregone conclusion, at least under current law, the federal court law, to disclose the key. Now, I like to talk about information privacy as a discrete privacy right. It is different from what some of the others that we opened up with talked about with regard to the privacy right. But it's very similar in the same way. We're talking about information about you or information that you have created or shared and the extent to which you get to control it as against the government. So information privacy is a specific unenumerated right. There's lots of twists and turns to it. But there's kind of a stair-step analysis. First of all, like regular paper in the home, regular papers and effects as discussed in the Fourth Amendment. If you've got it in your house, government's going to need a warrant. It's protected. But what happens when you go out of the house? Okay, you got it in your cell phone. Up until recently, the case law was that the law enforcement could get to it without a warrant. But thankfully, the Supreme Court recognized that these cell phones that we carry around are really contain far more revealing information than virtually anything else. And so relatively recently they ruled that the government must get a warrant to crack your cell phone. But I think that the court would extend Riley, which was the cell phone case, to other digital media such as laptops and storage media. And I think they would probably also apply it within the border zone. If presented with a proper question, I think they're going to subject that to Fourth Amendment. I think they will. And you can see that beginning to happen in the lower courts. The Ninth Circuit and the District Court in the D.C. of Columbia have both basically required a warrant standard. They said it wasn't, but it really was. The Ninth Circuit, for example, held that prolonged or intrusive border searches require some basis for suspicion of criminal activity. The D.C. District Court applied a probable cause standard to border searches and refused to apply a custodial search exception, in part based on Riley, the cell phone case. So we're beginning to see the lower courts chip away at the so-called border exception. They were waiting for something like Riley to kind of give them the excuse to do so.
Access to all electronic devices, like your computers and your car and your watch and everywhere else surrounding you that have your personal data. Like how? I'm trying to read the law a little bit, but can you?
That's a really good question, and let me try to answer it. Okay, lots of caveats. Riley was a cell phone case. But the logic of Riley come on, laptop, right? Portable storage, thumb drive. Come on, same. We carry the same type of information.
But I take it has to be an electronic device you have personal ownership of. Like if my phone communicated with NFC with a device, any data sent to that device would not be covered under Riley.
That is where I was fixing to go. Very good. And it allows me to launch into my critique of the third-party doctrine. Okay. If you are talking about information that is possessed by third parties or over which they have some right, then I think there's going to be a bit more time until we get there. Notwithstanding Carpenter. Okay. Strangely enough, I would predict that if we get another justice on the court, like Gorsuch, perhaps like Kavanaugh, I know many of you will shudder at this thought for other reasons, and that's fine. Okay. But if we do, I think you would find in relatively short time, you would find more protection of information privacy as against the government. There's some question with Kavanaugh as to whether he would have a national security exception. Okay, but Gorsuch is firmly in the digital information and property. He views people who have information about you that was created on a contractual basis with you or that you give to them for storage. He views them as mere bailees of your information, and they have the duties of bailees to protect that information, even as against the government. And so Justice Gorsuch, for example, would require a warrant for information such as cell site location information, but also for other information. If you read his dissent in Carpenter, it should give you great hope that maybe even the conservative justices of this court are beginning to realize the importance of digital information to individual liberty, at least in some respect. Allow me to talk for just a minute. Third-party doctrine has actually a relatively short history in jurisprudence if you look at things from a broader perspective like I do. Let's start with the Brandeis article from the late 1800s, where Brandeis was articulating the right to privacy. Now, as I mentioned earlier, that was in the civil context and civil torts. By the time he got to the Supreme Court, there was a case called Olmstead, where the federal government was wiretapping an individual. And the Supreme Court held at the time that that was not a violation of the Fourth Amendment. Brandeis dissented. And he tried to adapt his original right to privacy theory in the civil context into the Fourth Amendment. And his dissent, over time, kind of matriculated through the lower courts and ultimately got back to the Supreme Court and ultimately began to be the majority view about the right to privacy in the Fourth Amendment context, and after that, in other contexts as well. In fact, you can draw a direct line from Brandeis's dissent in Olmsted to Roe versus Wade.
And what was the
Roe versus Wade. Yes, you can. He was articulating a right to privacy in his Olmsted dissent. That perspective ultimately won the day in another case called Katz, where the court overruled Olmsted and said that a wiretap does violate the Fourth Amendment, and the federal government does need a warrant to effect a wiretap, at least insofar as it captures the content of the information being conveyed. And the way that it worked was, again, using the Brandeis formula. They said that for constitutional reasons, if someone has a subjective expectation of privacy, and that expectation is one that society is prepared to accept as reasonable, then this is a privacy right that is protected under the Fourth Amendment. And so, for the very first time, the court began to find a Fourth Amendment right to information that was unassociated with the traditional law enforcement beating down the doors and coming in and stealing your papers in effect. This expectation of privacy could actually travel around with you, because Katz was not at his home at the time. He was in a phone booth. Anybody remember what a phone booth is? His subjective expectation of privacy was expressed by him closing that door to the phone booth. And the majority in Katz found that this expectation of privacy was one that society was prepared to accept as reasonable. But I have always found that there is a property interest here. Always. I mean, even before Carpenter, I was out there running around saying information is property. You heard me say it 100 times. I know you have. Okay? And I was just ecstatic to read Gorsuch's dissent, because he said exactly what I've been arguing for 15 years. That we don't have to do this expectation of privacy dance. And it became a problem pretty quickly. Okay? Because soon after Katz, the court decided two other decisions that ripped away a whole bunch of the protection they had just granted. They created an exception to the expectation of privacy doctrine. Well, even if you have a subjective expectation of privacy, and even if society is prepared to accept it as reasonable, if this information is in the hands of third parties, it's an exception. The third party doctrine. And that was used to allow law enforcement to obtain financial or bank records without a warrant. They could get it on a mere subpoena. It was allowed for law enforcement to do what's known as a trap and trace, or pen registry, which is non-content, merely the envelope information of a phone call. This was before the internet, right? So this third-party doctrine just blew a big hole in the privacy rights of individuals. Even though this was very personal information, a lot of conclusions could be drawn from it. And indeed, you will find that some of the justices who were dissenting to the cases articulating the third-party doctrine, and in particular the Penn Trap case, were saying something that sounds a whole lot like what we now know as the mosaic theory. that information, digital information, even if it's not the content of the communication itself, the stuff that surrounds it, the envelope, the addressing information, the location information, the times, the endpoints, who you're talking to. All of this can convey a bunch of really important and potentially private and sensitive information about you. Who are you calling? You're calling your obstetrician. You're calling your pharmacist. You're calling your somebody of the opposite gender, or maybe same gender, that's not your spouse. This is all very sensitive information, but it's in the hands of third party. And so as a consequence of the third party doctrine, law enforcement can get their hands on it without a warrant. So, the court struggled with this reasonable expectation of privacy and the third party except they were all over the place. The cases, you read them, and if you're like me and you try to draw a line to, and kind of put it in the box so that you can understand, you end up going, they're just pulling this out of their ass. They want law enforcement to get it, or they don't want law enforcement to get it. It's not a very attractive defendant. Lord knows what the reason is. I can't figure this stuff out. So, we all kind of had a hint that what the Supreme Court had been doing in Jones and Riley and some of the other cases that began to take a look at information privacy in the various contexts, and in particular the Fourth Amendment. And we were really hopeful about what would come out in Carpenter. Okay? Now, I was actually somewhat disappointed in the majority decision. Okay? Because they did not just blow out the reasonable expectation of privacy test and return to the old style approach, the constitutional approach, the founders approach, that information is privacy and therefore part of your papers and effects. But what they did say, thankfully, they got the right result, so I guess I'll live with that. That cell site information, carrier provided cell site information, which determines your historical, which can convey your location, is so sensitive and revealing that they refuse to extend the third party doctrine to it. Okay? Trust me. When you start seeing the court saying, we're not going to extend this doctrine to it even though it applies, and all the lower courts have been saying, of course, the third party doctrine applies, you know that they're just playing games with themselves and they're trying to hide something that's going on. In jurisprudence perspective, this is all really new stuff. We're talking the last 10 years. Okay? So the courts are really still trying to get their arms around this stuff. I can tell you that the Supreme Court in the last 6 years has, if you look at the end results, okay, forget the analysis, okay? We lawyers, we use these big words and these big concepts, just like all the Roman Catholic priests used to stand up and talk to the penitents for an hour and a half in Latin. Nobody understood what the hell they were saying, right? All right, lawyers, we use Latin for the same reason, okay? Just to make us look important, look high-minded, smarter than you, all right? What's important to you is the end result, okay? And the end result is that the Supreme Court is realizing that there's all sorts of stuff out there that the government is able to obtain using new technology. And therefore it needs to be protected. Orrin Kerr, I don't know if you know who Orrin Kerr is. He's a famous constitutional scholar. I follow him. I read a lot of his stuff. I think he is certainly well qualified, but I tend to disagree with him a lot more than he would probably hope because he's a bit more pro-law enforcement. He did come up with a good idea, though. He calls it an equilibrium adjustment. When the Supreme Court begins to think that the government has gathered too much power through technological advancement, they do an equilibrium adjustment and give the rights back to the people. But remember one thing, okay? They still got to get a warrant. And that's the ultimate protection. As a practical matter today, this stuff is out there. It is available. The question is upon what terms and conditions can the government get it? And ultimately, the only protection we have is the demand for there to be a warrant issued only on probable cause to believe that the information to be received as a result of the search will reveal evidence of a crime. By demanding a warrant, you actually are imposing a fairly significant burden on law enforcement. Okay? For example, just to give you the cell site location information thing, right? It was dealt with in carpentry. Them simply saying, we have reason to believe that Joe Blow, a guy who committed a crime, is in a certain area. And we want to track him. They have to say that this cell site location, if obtained from the carrier, will reveal evidence of a crime. Not just that he's got a cell phone, not just that he's there, but that him being there is evidence of a crime. So the probable cause standard, as articulated in the Fourth Amendment, is very important, and it does impose a high burden. Now, yeah, can you get a warrant pretty easy? Sure you can, but you still got to swear to something, and there are consequences if you deceive the court. The Supreme Court, actually does try to pay attention to the practical consequences of its decisions. And what they are beginning to understand is that this information can yield very sensitive and private information. Information which is very analogous to the paper's effects and things that are described in the Fourth Amendment. And therefore it needs to be protected. And yes, this protection should extend beyond just in the home. It can extend and should extend to storage devices, other devices. I mean, we just had a very important Supreme Court decision, and one from an Indiana court, that actually was trying to ameliorate, an overreach by government, trying to rebalance individual rights as against the government. The courts are trying. They recognize, as we started from the beginning, that individual privacy serves a useful function. It advances civilized society. It maintains an aspect of individual autonomy and is implicit in liberty. I'm not talking about the government now. I'm talking about as against businesses. Okay? You need to exercise some initiative and try to take care of yourself. Take the steps that are necessary to protect your property. Okay, do you paint your house? Do you put a lock on your door? Do you close the door to the bathroom when you go in it? All of these things are things that you do. You learn how to do it. You learn how to protect your property. This is another example. Right? Now, I will grant you that at present, individuals have damn little negotiating power against these large companies. If I were empowered king to resolve this, what I would do is I would outlaw mandatory consumer arbitration. Okay. I would deem certain terms and conditions unjust and unreasonable, deceptive trade practices or unfair business practices, especially those where a person is required to waive privacy in order to enter the contract to begin with. I would prohibit companies from changing the term of the contract merely by posting something on some website on the dark side of the moon. I would return to a more balanced way for people to negotiate these contracts. If I don't want to give up my information, I should try to have some opportunity to negotiate with them about that. But as citizens, we also have some kind of obligation to control our information. Quit giving it away for these free products. If it's free, you're the product. It is clear that people do not have negotiating power. But on the other hand, you just need to quit giving this stuff away. If your privacy has value, quit giving it away. control it as much as you can. If it comes to choosing to not use certain things, then don't use them.
Let's think for a second about personal health information. So if we're traveling and get treated in an emergency situation, there's a very good chance that hospital will not have rapid access for electronic health records. It has to get faxed from one hospital to another system. That allows them to comply with the federal HIPAA regulations. But it's the case that the big healthcare companies don't want to share data with each other because it's valuable. They use HIPAA and our privacy as the justification for not having interoperable healthcare records. Do you think we have the balance right, or do you think we're letting them use that as a fig leaf argument to not share data?
The job of a corporation is to maximize profits in order to distribute them to your shareholders, consistent with law. And so, any corporation that's in business is going to try to find a way to maximize revenue and profits using whatever means it has possible, including your information. It is just the nature of the beast. Now, another strange thing about me is I don't like corporations. Okay? I think they should be foreign to the law and certainly not treated as natural persons. But, it is what it is. And we just have to understand what this beast is. And, quite frankly, I did a bunch of HIPAA work, especially when the statute was passed. And my first conclusion after reading that immense statute, why can't Congress pass a short statute, by the way? Is it possible to do something in plain English that people can understand and read in like 10 minutes? HIPAA is an exercise in waiver of privacy. That's all it is. First thing you got to look at is the caption of a bill. If it says the puppies and apple pie bill, you know that somewhere in that bill they're going to be killing puppies. Okay?
I think that's a quote of the night right there.
Somewhere they're going to be killing those puppies, and they're going to be stepping on that apple pie, maybe even banning them. Pay attention to the caption of that bill. If they say we're going to do this to protect your privacy, watch out for your privacy.
And with that, I think we
Learn more about Scott McCollough's law practice at .law.biz. This is the Plutopia News Network, 20 minutes into the future.